Na kutumia sahi na
habari yenu? Yes. Mr. Okay.
I appear from Morara.
Okay. Yes.
He is unable to attend court today for the sole reason that in the morning he was attending the public participation exercise.
There's a microphone where you are.
In the morning he was attending a public participation forum. And while he was there, he was attacked. And wounds, and he is badly injured. He was visited by the police. Together with his team in the local hospital, where he has been admitted with serious injuries. And thus he will not be able to attend court. I have a copy of the document from the local hospital showing that he has been admitted. But if the nature of the injury is required, we humbly pray that you are going to next week.
Your Honor, my colleague Mr. Salom had informed me earlier on before court began, and he did give me a letter which is from Nairobi Hospital, which the doctors recommended today. Which has a copy. Your Honor, but my view would be, since it's only a matter of a ruling, if the ruling can be delivered so that we are able to know, so that the next time we can pick a date when we can come back, depending on the court's directions. I'd propose that rather than adjourning the ruling. since Your Honor said that suggests choose the 8. But if the court can deliver the ruling so that we know on how to proceed.
Mm.
We have no objection to the
This ruling relates to application made by the defense counsel for rejection of the charges against against the accused person under section 89 subsection 5 of the Criminal Procedure Code. The main reasons given by the defense counsel in summary are that there is a mismatch in the particulars and that the charge sheet is defective, that the particulars of offense speak to defamation, which is no longer a criminal offense but a civil wrong, that the accused person is clearly not able to understand what he is responding to, and that the court has discretion under section 89 subsection 5 of the Criminal Procedure Code to reject the charge, and that the charge sheet has not been framed in line with the provisions of sections 134 and 135 of the Criminal Procedure Code, and that the particulars of offense are not supportive of the charge. On his part, the prosecution counsel submitted mainly, in summary, that the particulars are sufficient to enable the accused person to respond to the charge, and that the court need not go into the merits of the case at this stage. The issue for determination at this stage is whether there is merit in the application for rejection of the charge under section 89 subsection 5 of the Criminal Procedure Code as sought. Key consideration being whether the charge as framed discloses an offense known in law. The charge against the accused person has been preferred under section 27 of the Computer Misuse and Cybercrimes Act, number 5 of 2018, subsections 1 and 2 of which provide as follows, and I quote, a person who individually or with other persons willfully communicates either directly or indirectly with another person or anyone known to that person commits an offense if they know or ought to know that their conduct A is likely to cause those persons apprehension or fear of violence to them or damage or loss to that person's property, or B, detrimentally affects that person, or C, is in whole or part of an indecent or grossly offensive nature and affects the person, subsection 2. Any person who commits an offense under subsection 1 is liable on conviction to a fine not exceeding 20 million shillings or to imprisonment for a term not exceeding 10 years or to both, end of quotes. The particulars of offense on the body of the charge sheet state inter alia that the accused person on the 28th day of September 2024 at a known place within the Republic of Kenya, jointly with others not before court, while using Xcop account dubbed at Morara Kebaso Senior, knowingly without lawful excuse posted false information to it, and then the information is produced, content whose information you knew to be false and calculated to tarnish and discredit the reputation of David Langat, unquote. The statement of charge does not, however, specify under which of the three paragraphs outlined of section 27 subsection 1 of the said act the charge has been preferred, whether paragraph A, B, or C, or some or all of them. Clarity in framing charge is a requirement under section 134 of the Criminal Procedure Code, which provides as follows, I quote, "Every charge or information shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense charged," unquote. The particulars of offense on the body of the charge sheet must therefore, as a requirement, capture all elements of offense charged, and it is only then that the particulars would disclose the offense charged. In this case, the particulars of offense do not capture or outline the elements of offense of cyber harassment as defined at section 27 subsection 1 of the Computer Misuse and Cybercrimes Act already outlined herein above. I am guided by the authority of Sigilani versus Republic, 2004, volume 2, KLR at page 480, where it was held as follows, and I quote, "The principle of law governing charge sheets is that an accused person should be charged with an offense known in law. The offense should be disclosed and stated in a clear and unambiguous manner so that the accused person may be able to plead to a specific charge that he can understand. It will also enable the accused to prepare his defense," unquote. In that case, the charge sheet was found to be defective for not including essential ingredients of offense charged in the particulars of offense. As the High Court, while dealing with section 89 subsection 5 of the Criminal Procedure Code in the case of Joseph Njeru Mukuthu versus the Director of Public Prosecutions, 2017 EKLR, stated, I quote, "The section is very clear that the court has power to reject a defective or a wrongly framed charge. The prosecution is at liberty to amend the charge to which the accused person may be called upon to plead," unquote. In the instant case, the charge is of an offense known in law, but the particulars of offense on the charge sheet do not capture the requisite elements of the offense as defined, and specificity in the particular paragraphs under which the charge is brought is lacking. And for the foregoing reasons, I find the objection raised and the application made by the defense counsel merited. there is good ground for exercise of discretion to reject the charge sheet herein as framed, though the prosecution is at liberty to properly draft and prefer a proper charge. The charge presented before this court on 1st of October 2024 against the accused person is rejected for the reasons already stated under Section 89, subsection 5 of the Criminal Procedure Code, and the accused person is accordingly discharged. The cash bail deposited in respect of this matter be released to the depositor thereof, and the prosecution and the defense be supplied with copy of this ruling and of the proceedings upon formal request in the normal manner, and payment of any requisite fee for the same to be assessed in the normal manner. Thank you. That is the end of the ruling.